Imagine you are a resolution professional. You are managing a stressed company, handling crores of rupees belonging to banks, and suddenly you are accused of demanding a bribe. Your first reaction: I'm not a government officer. How can corruption law apply to me? But is that really a valid defense? Let us break down an important landmark judgment of Mr. Sanjay Kumar Agarwal versus Union of India. Background of the case. In this case, a resolution professional was accused of demanding a bribe during the CRP process. Authorities initiated proceedings under the Prevention of Corruption Act 1988, Section 7. The resolution professional challenged this and argued, I'm not a government employee, I'm not a public servant, therefore the Prevention of Corruption Act should not apply to me. A simple argument, but legally significant. Core legal issue. The key questions before the court were: is a resolution professional a public servant? Can bribery provisions under the Prevention of Corruption Act apply to such professionals? Court's analysis. The court approached this issue step by step. Position under IPC. The court held that a resolution professional is not a public servant under Section 21 of the IPC. So yes, the RP is not a traditional government official. The court applied another test, that is functional test. However, the court emphasized an important principle. It is the nature of duties, not the designation, that matters. Let us examine the role of an RP. The RP takes control of the corporate debtor, manages the insolvency process, handles claims of financial creditors, deals with public funds through banks. These functions directly impact public interest. Broad scope of Prevention of Corruption Act. The court noted that the definition of public servant under the Prevention of Corruption Act is very wide. It includes any person who performs a public duty, even if they are not a government employee. Therefore, an RP falls within this definition. No immunity under IBC. The RP relied on Section 233 of IBC, which provides protection for actions taken in good faith. But the court clarified, protection applies only to bona fide actions. Allegations of bribery can never qualify as good faith. Hence, no immunity is available in such cases. Final judgment. The court concluded a resolution professional is not a public servant under IPC, but is a public servant under the Prevention of Corruption Act. Therefore, Section 7, bribery provisions are fully applicable. In short, an RP can be prosecuted for corruption. Key takeaway. The important takeaway is that accountability depends on the function you perform, not your job title. Even private professionals can fall under anti-corruption laws if they perform public duties. This is C&IP Praveen Agarwal thanking you for watching. Stay connected with Synergy Business Advisors for more practical insights on company law compliance and business regulations. Thank you so much.